The question is that the motion be agreed to.
Mr Speaker.
Honourable Phil Goff.
Mr Speaker, Labor is supporting this bill as a relatively modest but nevertheless constructive way of dealing with the problem of offending while on bail. I say relatively modest because the measures in this bill will tackle the problem around the edges, but it won't tackle the fundamental problems of why the level of offending on bail are so high, and I want to come to that in due course. There is naturally in this country a presumption of innocence until proven guilty, and I don't think any member of the House would seriously want to challenge that presumption. It is embedded in our system of justice. And if we have a presumption of innocence, then we have a presumption that people will be granted bail. That presumption can't be absolute. Would be crazy for it to be absolute, because you also have to take into account public safety when you're dealing with defendants that are charged with committing, in some cases, very serious offences. So right now the judge has the presumption and then takes into account, one, whether the defendant is likely to continue offending. If that's the case, then the person needs to be locked up. Two, whether the person is likely to abscond. Again, if there is evidence that that is likely, then remand in custody is appropriate. And three, whether the defendant is likely to do anything that might pervert the course of justice, such as interfering with witnesses while that person is on bail. This bill does not fundamentally change the discretion of the judge or the decision that the judge makes, presuming innocence, but weighing out against public safety factors. But the reason why change is needed, I think, has become very obvious in recent years. In the course of the committee, we heard from traumatised people who had lost family members murdered by defendants who were at that point on bail, having faced other charges on sometimes quite serious offences. And the particular case that achieved a lot of publicity was the case of Christy Marceau, a tragic case of a young woman murdered by a man who had previously kidnapped her, abused her, and then he was given bail to live in close vicinity to the Marceau household. And that family understandably wanted to know why. Why was bail given when the police had refused or came out against the giving of bail? We heard from other families in that case. Those individual cases are backed up by statistics. 17% of those who are on bail go on to re-offend while they're currently on bail. And often that's relatively small offences, relatively minor, but not in every case. In the 5-year period from 2006 to 2010, 23 people on bail went on to commit murder, 21 to commit homicide. About 763 went on to commit acts of a sexual nature, serious sexual offending, and a whopping 7,146 went on while they were on bail to commit acts that had the effect of injuring other people. Those statistics look huge. I guess you have to see that fairly in context. Those statistics represent a relatively small percentage of the 450,000 people who were bailed over that period. But it's not small if a member of your family is the victim of a crime committed by somebody on bail, and therefore we needed to look at that, and we needed to do something to try to ensure that there is greater scrutiny given by judges to people with a high likelihood of offending. And that's what that bill basically does. This bill focuses on a reverse burden of proof. At the moment, the norm is that if you don't want somebody to get bail, the police have to prove to the court that that person is not safe to bail. The reverse burden of proof turns it on its head and says the defendant needs to demonstrate to the court that they are safe to release. Now, the net impact of that, as we discovered in questioning people before the committee, was basically that judges will look more carefully at cases on the margin. I don't want to exaggerate the impact this bill will have. That would be unfair to the people who made submissions to it. We learnt that it will mean probably an increase of 50 prison beds. 50 prison beds. We're talking about more than 90,000 people being bailed each year. It will affect about 350 people because of the flow-through effect, and that has an impact. It's much more significant than Simon Power's ludicrous piece of legislation that this government put through before the last election that had the effect on 10 people. 10 people. That was, as an eminent professor of law said, simply window dressing. It won't have the same impact as the fundamental law that it's amending, the Bail Act that I put through in 2000, which lifted by 200%, 210% actually, the number of people remanded in custody. That had a fundamental effect. I believe that it was necessary at the time, but I don't want to again create the impression that the answer to offending on bail is simply locking more and more people up. We lock up 43 people per 100,000 remanded in custody while their trial is awaited. And that compares with the Australians, which is 30, our 43 against 30, to the UK, which is 25, Finland, which is 10. So we are locking up a relatively high proportion of people on bail. And that's why I say this bill just deals with things around the margins. What we've got to do is make some fundamental changes to the way in which bail works. And these are the sorts of things that the Labor Party is considering. And I'm pleased that the Minister picked up the fact that if you've got somebody waiting 18 months before their case is heard, then of course there's going to be an increase in the likelihood of that person offending while on bail. Justice delayed is justice denied, and the increasing length of court cases, particularly before the district courts in Manukau and Auckland, is where you've got to tackle this problem at its fundamentals. So let's look at making justice more swift so that the cases aren't waiting month after month after month, and the person that's bailed, and more likely to be bailed because of the length of time they're waiting, is likely to reoffend. The second thing that we looked at was the ability of the police in practice to appeal a case where they applied for bail to be withheld so that the person would be remanded in custody and the judge came to a different decision. I'm not saying the judge was right or wrong, but if the police really believed that the person should be remanded in custody, they need to have a way to appeal that decision swiftly, otherwise it's theoretical. The person is let out and the police say, well, the person's out now, we won't bother. And the sense that we got at the committee was that police weren't actually appealing cases, even where they thought the judge had got it basically wrong. The third thing we need to do is to give the judge better risk assessment tools. You've got to say that when you sit in the court and you watch the judge making decision after decision, they are decisions that are made in minutes. They are not decisions that are made after great contemplation. They can't be if you've got 91,000 bail cases a year. So you've got to do something more to assist judges in terms of risk assessment. We need to look at that. And fourthly, and I think quite importantly, is that we need a better review process of where the bail decision in hindsight was wrong. Now, I want to make something very, very clear. That is not about interfering with the judicial process. The review process needs to occur within the judicial system, maintaining judicial integrity and judicial independence. But the head of bench, perhaps with the task of looking at cases like the Marceau case and say, we got it wrong in hindsight, it had tragic consequences, how did we get it wrong, what can we do about it? And I think that review system could be considerably strengthened and made more transparent. So what I'm saying, Mr. Speaker, is this bill does things on the margin, and I'm comfortable about the extending the reverse burden of proof in murder cases and cases of serious, violent and sexual offending. We had that in the original Act. Expand it by all means. I think that it makes sense where you've got serious Class A drug charges, where we know more than a third of the people bailed on serious Class A drug charges are out dealing again while they're on bail. Yes, of course, a reverse burden of proof there, or the offender having, or the alleged offender having to prove to the court that it's safe to put them out. On young defendants, I want to touch on that briefly. Look, if you're 18 or 19, you are an adult in every aspect of the law, and therefore a special presumption of bail is not warranted in that case. If you're 17, Mr Speaker, and I'll finish on this point, if you have a previous term of imprisonment...
Yes, time's expired. Jackie Dean.
Thank you, Mr Speaker. I'm very pleased to speak in the third reading of the bail amendment bill.